Who's the attorney? Milo. Mayhem Law Firm is on. Myers. Who's David Myers? I gotcha. Thank you. Please. So good morning. I'm Judge Person. I welcome everybody to court this morning, and I welcome everybody to court. And just real quick question. Okay. Mr. Martin, you're not driving, right? It looks like you're not driving, but I just want to confirm.
My name is Mr. Holmes.
Yeah, I wasn't asking Mr. Holmes. Mr. Martin, Ben Martin, you're not driving, right?
Definitely not, Judge.
Thank you. It's just not safe, so I appreciate it. So I just want to welcome everybody to the municipal court. My name is Judge Person. I'm going to make some brief announcements. Before I do that, Mr. Matson, Mr. Martin, I'm going to go ahead and let y'all discuss the Ernesto Falduto and the Nicholas Corey cases. That ought to be time efficient wise. That makes sense to do that right now. And so just folks who are here, I want to kind of give you an overview. I also want to confirm who's here. There's only one person I couldn't identify. It's a phone caller on 254 ending in 065. Can you speak up? Good morning. Phone caller. Hi. Can you hear us? So phone caller, this is the judge of the court, and the phone appears to be a 254 number ending probably in 065. I guess I can call the names of all the people who aren't here. That's less efficient. Michael Baines, are you here? Can you unmute Michael Baines? Emily Blanding, are you here? Can you unmute? Miss Blanding, I believe that is your phone. The clerk confirmed.
Yes, it is. Can you hear me?
Well, I can now. So I want to let you know it's fine to be on a phone call, but we're in a kind of an order. I was watching as people logged in, and we're sort of in an order. And so what I want to do here is just make sure that you know that when I call your name, now that I've got it, when I call your name, just be listening so that you don't miss your chance. Okay?
Yes, ma'am.
Okay, thank you. Because there are a number, you can't see it, but there are a number of people in the quote room with us. And so it might be a few minutes. Okay. So just keep
Yes,
paying.
ma'am.
It's not uncommon. Folks on the phone will sometimes get busy and not remember that they're really on the phone. So I highlight that a little bit, not you particular, but just folks on the phone. So thank you. And I'm going to remute you. I keep everybody muted till it's their turn. So I just want to let everybody know just a handful of things that might be helpful. One of the things that is good to note when you're in a court like this one, one thing that we want to understand is the cases here are fines and costs. They don't result in the imposition of jail time. People can sometimes have an arrest. It's a limited time when we do arrests on Class Cs. And so I just want to kind of let you know that just to stay aware. Sorry, I'm trying to do too many things at once. I probably shouldn't have. So yeah, and so when you're given this kind of ticket, what happens is if you're convicted, you owe fines and costs. Now, I want to talk to you a little bit about the pleading options. So when you're given that ticket, it's an accusation. That's what a ticket is. It's a way of accusing a person. And when you give a plea, you're giving your answer or response to that accusation. And there are three options for pleading: guilty, not guilty, and no contest. Now, guilty means I did this, okay? Not guilty means you're contesting the charge. We all have the right to a trial. And a trial in this type of court is a 6-person jury. That docket splits off and does a slightly different thing. There's a pretrial online, and then there's an in-court pretrial, and then a trial. And the reason for that is just a long-winded legal thing that I'm not going to bore you with right now. But I kind of want everybody to know the direction you're going, depending on the plea that you enter. So if you plead guilty, again, I did it. Not guilty is I want the case to be proven against me. That's really what that means. We don't have an innocence plea because we're not required to prove that we're innocent until the state proves their case first. Okay, and then we call that the burden shifts, right? You've probably heard that in TV shows and what have you. In court, they have to go first and make a showing, a threshold of showing, and then it's that person's turn to defend themselves. And so it's just there's a long history behind that one, but it's important. And if you plead not guilty, we're going to go in that direction, heading toward trial. If you plead no contest, it really means just that. I'm not contesting it. I'm not going to say I did it. I'm not going to say I didn't do it. I just want the state to move forward with sentencing. Now, normally we're found guilty, it goes on our record, we pay those fines and costs. There's some exceptions along the way. First of all, in terms of payment, I always ask for people's income information for sentencing in case I need it, and also for setting a bond in case we're contesting the charge. Either way, it doesn't matter. I usually request to get that information. It helps me just make better decisions in terms of setting bonds and so forth. The other thing that happens with that is, in terms of doing it that way, I'm looking at, sentencing options as well. So that's why I asked for the income information. And then if you plead guilty or no contest, and I'm moving into sentencing, at that point, what I'm doing is looking at your options, okay? And there's still 4 ways to gain a dismissal when you're in a sentencing option in a Class C court. One is if you can have something dismissed through compliance dismissals. 2 is through a driver safety course option. 3 would be through a deferred disposition. And 4 would be through teen court. Now, let me kind of explain what those are. Before I do that, Mr. McMahon's office Ms. McMahon's office is represented by Mr. Martin. Mr. Martin and Mr. I don't know where my words are today, Mr. Matz. Right. I mean, I totally know his name, but anyway, Mr. Matson and Mr. Martin, let's talk about, are we going to talk about the Foldito case first or the Corey case?
We'll do Faldito first, Your Honor.
Okay. Where are we with that case?
We're going to go ahead and set that for final pretrial. I'm going to provide Mr. Martin with discovery, and I made an offer and he will be taking that back to his client. Okay.
And so that is scheduled for June 15th at 1:00. And the only thing I need in terms of discovery from you gentlemen would just be that final, what I asked for the defendant's office to do is just to sign that you received it. I don't look at the discovery. There's no in camera of that. It goes straight over to you. And then the only thing I'm looking for, I require the state to list what they've provided and for both of you to sign off on it. So I'll look to receive that sometime soon when y'all get that done. And then we're set for final June 15th at 1:00. And thank you. And as to the Nicholas Corey case, where are we with that, Mr. Matson?
The status of that case is the same, Your Honor.
Okay. So and we're setting it the same date because why make you come twice to the court? 1:00 on the 15th of June. Discovery, again, the same thing. And I'll just note that an offer was made and I don't need to know the contents of that offer. Mr. Martin, do you have any further questions or concerns that you need to draw attention to the court at this time?
No, Your Honor.
Then you are good to go, sir, without further request.
Thank you, Judge. Have a good day.
Thank you. You too. Okay, and then, so I was just going through those 4 dismissal options, and let me just tell you a little bit about how they work. Compliance dismissals are things that can be brought up to date and dismissed. I actually don't see any of those on my docket this morning, but the way that those work is that if there is one, and I'll look more closely when it's your opportunity to be heard, I look for those and I highlight them to you and I talk to you about them if it looks like we can get you to a dismissal, because the law says the judge shall, okay? And I'm not going to go through the list right now. There's like 14 of them, and they all have little bitty different rules. And I don't expect everybody to know them. And I also don't expect to take 35, 45 minutes to go through them all when it may not even be relevant for the day. But you're welcome to ask me about it. Just, know that I will be looking for that. And if you want to request or ask questions, that's fine. Okay. The second thing is a driver safety course option. To get to that one, you have to have a Texas license and be on time to court, not have been in the previous 12 months for ticket dismissal process. And from there, pre-qualifying, we go into what if the offense is eligible. And then if it is, there's things to do to get into that program and then things to do to exit it properly and do it successfully. So I'll walk through that with you if it looks like you might be eligible. That'll just be the commitment I make at this point. Because there's a lot of details and I find people gloss over when I hit too many details out there, which is totally understandable. But just ask me if you have questions about that. The main thing to highlight there is you save money and you keep it off your record. And if that's your case, I'll explain it to you when it's your turn, okay? Deferred disposition is a really good one where the others don't work, okay? And that one really, because it's more expensive and it's more involved, okay? So it's not as convenient as the previous two. And so, but it's still there and it's available and it's a good tool. So the way that works is we put a court order in place. It lists the things you need to do to gain a dismissal. If you do them, you get a dismissal, okay? The number one question people have about a deferred disposition, besides what does deferred disposition mean? And that simply is deferred means a delay, disposition means to finalize or make final. So we delay making it final. We put that piece of paper in place that controls what we're going to do. If you do the things listed, you get a dismissal. It's easy to know what you're supposed to do because it's written down and you sign it. Okay. But the other question, the other number one question is, how do I get that? And the answer is you have to request it. So guilty or no contest, I'd like a deferred. It's on the sheet that we would have had you fill out if you came to the front window. You could check off on it, but you might or might not have understood what it was. So you can still ask me today if we haven't already done a sentencing option. If you're already in a sentencing option, it's gone, that option. It might be too late, but as long as you've entered a plea and I haven't accepted the plea yet, you can still make the request. So I'll talk to you about that, but just say, I'd like a deferred. That's the way that you ask. It's really simple. I'd like a deferred. And it's important to note that because the law says, I assume you're supposed to know that. Most of us did not wake up thinking about that. So I think the answer is to explain it. The fourth option is teen court. If you're in high school or middle school, I'm going to be looking and pushing teen court on you to see if you want to do it. And the way that basically works, it's very similar to a deferred, except that you're presumed to be a student in school. And so a few things that relate to school are different. Okay. And so that's really my 101 of how things move through a court. I already explained if you're pleading not guilty and then moving things forward in that direction of a trial. The other 4 options available from the court are compliance, driver safety course, deferreds, and teen court. Okay. If you have questions, when it's your turn, I'm going to unmute you. I don't unmute everybody because if we all unmute at once, it's literally just the sound interference from your backgrounds will cancel out this system and no one can hear anyone else. So, but when it's your turn, you of course will be unmuted and I'll be asking you to do that. Mr. Myers, Mr. Mattson, y'all are due for pretrial. I'm going to go ahead and move that forward. Mr. Myers, what that means for you this morning is I'll literally move you to a breakout room. You and Mr. Mattson will have a conversation. Then y'all will come back to this room. One thing I want to let you know, though, is Mr. Matson is an attorney. He represents the state of Texas. For purposes of your offense, which is a speeding charge, that means that he represents who filed the ticket, the state, the officer. And so he's not your representative. You probably knew that, but I like to just make sure everybody knows that. And so just be aware of who he is. And, he's here to review his case just like you are. And then we're looking at whether we're moving toward trial. And so I'm going to go ahead and make that happen. And that should happen for you automatically, Mr. Myers. You probably won't have to click on anything. Mr. Matson, Mr. Myers has moved forward, and I believe his system is taking him there now. Okay, and then I'm moving forward as well. And Estella Ortiz was the first person who logged in. Ms. Ortiz, if you could, go ahead and unmute. Excuse me. Let's see. So I did receive your plea. The speeding charge was, sorry, I'm just re-looking. Yes, I'm looking at your charge. It's a November 9th charge, and you requested a deferred, which I will grant. And then I'm just looking at your financial stuff, and give me 2 seconds. I know DoorDash is one of those things where it's kind of hard to predict what you're going to make. And you're a student full-time at Temple College.
Yes,
And 2 children at home. Are you the only source of income to your home?
I am.
Okay, so, right, at this time, and I'm sorry, I've got to get a stamp. And apparently throw my stamps around. Hold on just a second. Okay. So I agree with you. What I'm going to do is find you indigent and order community service in lieu of payment. Do you have any disabilities that I need to take into account? I didn't see anything.
I don't,
What about
however,
you?
if I can make, I worked it around, my financials since when I sent in the papers.
Okay,
I can get it paid off in 3 months. I don't have any family or friends in town to do community service as far as my kids.
okay.
Sitting. So if that's an option, I would appreciate that,
Yeah,
too.
it's an option. I can work with you. What I will do then is, and let me just instruct the clerk on the fine on her case. Cut the fine in half. I'm going to do a reduction on your fine, and we'll get that number here in just a moment. I'll cut the court costs I can't control. So the state sets court costs, the judge sets the fine. The court costs, the state does not let me do anything with that.
Okay.
The fine, I can do something with that. So I'm going to cut that one in half. Let me get you a new total.
Okay, thank you.
And then we'll talk about 3 months to pay. That's
Yes,
no
ma'am.
problem. That is no problem. Your deferred would begin today, and it
Okay.
would end September 20th. That's 120-day deferred. And you are not one that I would require. Let's see, let me just double check. I'm not going to require a class. Sometimes I do, sometimes I don't. And in this case,
Thank
I do
you.
not think that I will. Your total is dropping from 254 to
I'm sorry, the sound went out.
That's okay. Your total dropped from 254 to 194.
Thank you. I appreciate it.
And that would be payments of $65.
Okay.
Let me see. Give me one moment.
Yes, ma'am.
65, 65, and 64. Do you have a calendar in front of you?
Yes, I do.
Okay, just talk to me about in the next 30 days, when could you make the first payment?
Let's see.
The 30th day would be around the week of the 20th of June.
The 15th.
June 15th?
Yes, ma'am.
Okay. And then the next payment about 30 days later, what would work best?
That would be. I could either do the 8th or the 14th.
Either one works for the court. Let's say the 14th, you can always do it earlier if you wish.
Okay.
And then a month after that, sometime in there, what works best for you?
The 12th?
The 12th of August?
Yes.
Okay. Okay. And I'm signing that deferral now, and I need to get your signature on that. There are two ways that we can do that. The
Okay.
easiest by far is if you come up to the court and sign it, and we hand you a copy, and we tell you all the different ways you can do payment online and by phone. The other is if we email it to you, you print it, sign it, and email it back. I can't take an e-signature. I can only take a legal signature. Which will work best for you?
I can do email. I have a scanner printer combo thing.
Okay, we will send that to you shortly. And then just make sure, call and confirm that we got it back from you, okay?
Yes, ma'am.
Okay, do you have any questions?
No, I thank you.
Okay, thank you, Ms. Ortiz. You have a good day.
You as well.
You're good to go. And then I'm next talking to Jonathan Holmes. Mr. Holmes, give me just a brief second. I'm going to go ahead and take Mr. Matson's. Oh, actually, I'm not. I'm going to move the gentleman back over. Excuse me. We'll wait for that to happen. Mr. Holmes, we did receive a request for a payment plan and a plea of no contest on a charge of no insurance that is dated from accusation date April 2nd. And if you paid it, it's $281. I can do that, but I'm also authorized, based on the income information that you provided, to order community service. I can do a payment plan of as low as $25 a month, or I can go ahead and convert this to community service. What would work best for you?
If you could please do community service, I could do that. I'm in the process of looking for a job now, so I just got my social security card and stuff. So
Okay, so if I do community service, which is where I'm inclined to go with this, it would be 14 hours and it would be due no later than July 19th. And I have a bunch of information for you that explains how to do it, the rules, a timesheet, and a list of providers that are already pre-approved. Can you come by the court to pick that up today?
yes, ma'am, I can. I'll be in town.
Okay, what time should we look for you?
I'll probably be there around, I got an appointment at 10, so it'll probably be around 12 or 1.
Okay, I'll just put 1 o'clock. If you're early, it's fine. We'll have everything at the front desk for you, the same place that you came by before. It should only take you about 10 minutes. There's one form to sign, the rest just a packet. Okay,
All right. Thank you, ma'am.
thank you. You're good to go.
All right. Bye.
Bye-bye. And Mr. Myers, Mr. Mattson, where are we on this matter?
Your Honor, Mr. Myers is going to change his speeding ticket plea to no contest, and I will be dismissing the FTA.
Okay. All right. Mr. Myers, I don't think I received any financial information from you, which is fine. Are you able to pay the balance today, which is $405.60?
I paid the cash bill.
I see. Somebody just whispered that to me. I'm sorry, I didn't see it on the form that I had. Okay, so I'll go ahead and accept the plea of no contest. I will sign the dismissal of the violation of the promise to appear. Mr. Mattson will email that to me sometime in the course of this morning. And once I sign it, can I email a copy to the email we used to set up this meeting?
Yes, ma'am.
Okay, that should be not very long from now, sometime this morning. If you don't receive it for any reason, Mr. Meyer, just call and check on it and see where it is, because we'll be emailing it probably within the next hour. Okay.
Okay, will they be reimbursing me the difference in the cost?
Let's see. Did he pay cash? Yes. How long does, just give me 1 second. Yes, is the answer, but I have one more follow-up. How long
Yep.
does that take? Okay. That takes a little while. It has to travel through the inner workings of City Hall. We send it today, but it does take some time. The finance department does that. I'm not in charge of them, but we'll send that order to them today. Okay.
Okay.
It can take several weeks. So just want to caution you on that, but you definitely will receive, that's a refund of $395.20. Okay. Okay. And I'm just making a note. All right, I'm just making notes that we talked about that too. Okay, Mr. Myers, thank you. Do you have any further questions?
No, ma'am.
Okay, Mr. Mattson, do you have anything further on this matter?
No, Your Honor.
Okay, we'll look for your dismissal this morning. Okay, Mr. Myers, you're good to go. Mr.
Yep.
Mattson, thank you, sir.
Yeah.
Mr. Mattson, your other person was Claudia Walker. She's not here. That is a no-show. And so I'm going to go ahead and let you go until we have a hearing. And I believe that's going to be at, is it at noon or 10?
I think it's at 10, Your Honor.
It's at 10.
Okay.
You can stay on if you want. Or you can come back in because I'll just leave the meeting open. Okay?
Okay.
All right. Thank you.
Thank you.
And then I was about to talk to Ms. Ayala. I'm saying it wrong. Ms. Ayala, good morning.
Hi, good morning. You're saying it right.
Okay. And is your mom with you?
She's right
I
here.
see. Hi, good morning. What is your name, please?
My name's Christian Ayala. Christian.
Christian.
Yes, ma'am.
Okay. And let's see. This is considered to be an assault by contact. And I did receive a plea of no contest. I'll talk to you about that in just a minute. Also, do we have the juvenile forms? Give me just one moment to check on something. She's 13, so I would assume we sent juvenile forms. It's a criminal case. We did not send them? Okay. She came in on May 2nd, so there's been plenty of time. Can we print them, please? Because I don't have that either. There are a few things I want to give you, and give me just a moment to get those printed up. Okay. There are a few things I need to, unfortunately, to walk you through. So one of them is that there are certain rights that you have under the law. It's Raleigh, right?
Riley.
Riley. Okay. So Riley, you're 13 today? Okay. And in court, we don't go, They can sound like the same thing. So yes or no is
Yes,
what we do. And you're charged with the offense of assault by contact, and that is a misdemeanor. Look, can I see it, the offense? We always want to think this beforehand. This and that especially, because I don't know what kind of assault by contact it is. I don't have the complaint. I don't know if I need a stipulation. I still want to look at it and have it printed. So you're charged with assault by contact, and that is a Class C misdemeanor. You have the right to hire an attorney to represent you. You have the right to have that attorney present with you at all times if you're being interviewed or questioned by attorneys or persons representing the state. You also have the right to remain silent and not say anything. You are not required to make a statement, and any statement you make can be used against you, though, in court. And you have the right to stop any interviews or questioning at any time. Do you understand?
Yes, ma'am.
Okay, Mom, do you feel like she does?
Yes, ma'am. So, Your Honor, I do have a question.
I'm gonna need to go through these things first, and then we'll get into the questions.
Okay.
Can you hold the question for just a few minutes?
I sure can. Yes, ma'am.
Thank you. When y'all come in later, I'm gonna have you sign what I just read to you.
Okay.
Yes, ma'am.
The next thing is I'm supposed to confirm your address. I don't like to give people's address out online. I will ask if you live in Temple, and if you live, the address, I'm not going to give the street, but it's 221. Is that a correct address?
Yes, ma'am.
Okay. You'll sign and confirm that when you come in, okay?
Yes, ma'am.
The next form just will tell you that you have a duty to keep your address current until your case is completed. And that means a zero balance or a dismissal, whichever is appropriate for your case, okay?
Yes,
And
ma'am.
that means that if you move, you have to tell us in writing, okay? And if you don't, it can turn into a charge if you don't do that, okay?
Yes, ma'am.
Okay. Mom, what is your date of birth? Excuse me, but I do have to ask.
December 16th, 1988.
I can't do the math real quick. Tell me your
33.
Okay. And y'all will sign just saying that you know that there's an ongoing duty to keep the address current until everything is done, okay?
Yes, ma'am.
And the next form is actually a bit short and it's more formal, but it says a further charge can be filed against you if you don't finish and complete your case, okay?
Yes, ma'am.
And then the very last form, it's going to look like this, and it's got lots of teeny tiny writing on it. And I apologize, but it's required by state law to give it to you. And it basically tells you if you are convicted of something before you turn 17, when you turn 17, you can have it removed from your record. And in this type of charge, you would file a request to do that here at the court building. Here's where you do that one, okay?
Yes, ma'am.
Okay, so I'll have those at the window. And the next thing I want to just ask you before we go any further is whether you understand what you've been charged with. It's an assault by contact, and the complaining person appears to be someone by the name of Bailey Smith through Devin Kane, which might be a parent. And they are claiming that you forcefully pushed Bailey Smith from behind, causing them to fall to the ground. And that is alleged to have occurred on March 8th, 2022. Do you understand that someone is accusing you of doing that?
Yes, ma'am.
Okay. And earlier, I also talked to you about that the options for pleading were guilty, which really means I did it, not guilty, which means I want it to be proven against me. You don't have to give a reason for that. By the way, you can just want that, but it can be because you're innocent. It can be because you just want that. It can be any reason, okay? And you're not required to explain that reason to me. If you say not guilty, that's your plea, okay? And you're already presumed to not be guilty right now, okay?
Yes,
And
ma'am.
then the other one is to plead no contest. And with no contest, it's just saying, I'm not going to admit it or deny it. I just want to move forward. And that's the plea you wrote down. I'm not going to accept it yet because I want to talk to mom, okay?
Yes,
But I also want to understand first, do you understand that you're presumed not guilty? And the three options for pleading, do you feel like you know what those mean?
Yes, I do.
Now, mom, what was your questions? What are your questions?
I just had a question about the deferred dismissal. I didn't quite understand that when we filled out the papers.
Right.
I didn't know if that was an option for her.
It certainly would be. I would look more toward teen court though, because really the difference between the two, the effect is the same. It's a dismissal. With teen court, you don't pay the cost of the ticket, and with deferred, you do.
Oh, I see.
So the difference is like $296. So, and teen court is $20. And we are probably largely going to do the same exact thing with one or the other. But you might not have understood either of those options when you were filling the form out. And I would presume that with an underage person, even though I'm legally supposed to presume that you know, I would still presume that you don't. So, so that's a good question. A deferred is really a delay, and we put in some rules and a payment structure and a class usually for this type of thing. And then you get a dismissal if you do all of those things. Here, it would be just slightly different. We'll probably look at some classes. I want to talk to you about that because I saw that there might be some classes happening and so forth. So, and I just wanted to look real quickly. Felton. Okay, and so okay, thank you. Okay, so what other questions do you have, Mom?
I think that's it.
Okay, Rayleigh, what questions?
I don't have any.
Okay, so I will accept your plea of no contest. I will accept your request for teen court. Teen court requires a $20 cash fee. Can you pay that fee today?
Yes, ma'am.
Okay. And then I did read in what you wrote down that you wanted to talk to me, which is all good, and that you were requesting an anger management class. Have you done one yet?
No.
Ma'am.
Okay. We have anger management classes that are available online. We've been doing most things online since the pandemic. The net effect is it's harder to find things in the community right now. You're welcome. If you are seeing a counselor, we could look at that and what you have available there. But otherwise, I would order an anger management class. And
Yes,
you would, sorry?
Yes, ma'am.
Okay. And just one second. What options do I have on that? Hours of that? Tell me what happened here from your perspective.
Well, in class in 8th period, we were I was getting my backpack and stuff in my locker, and Bailey had came up to me and told me that people were saying that I wanted to fight her when I had never said that. And she was like, well, if you're gonna fight me, then you can come and meet me outside in the courtyard, and if you want, and I will rock your world, and you can see that I can fight and stuff like that. And she was telling me a lot of mess. And there were two other people there, Zanaya and Carla Crumby. And then when later on came and it was after the bell, and we met her in the courtyard and we were talking, and she had like bumped into me, like it had bumped in my shoulder. And when she had walked away, I could hear like mumbling stuff underneath her breath, and it just really had made me mad because past on people have been telling me that she was talking about me, and that it really made me mad. And I tried to confront her and tell her that if she was talking about me, and she told me no. And then whenever she had pushed me, I just got really mad and let my anger, and I had pushed her.
Okay. So y'all did not fight outside.
No.
Okay. All right. I just kind of wondered what happened. Mom, what do you think is going on with all of this? What's your understanding?
It kind of makes me emotional because she's never been in trouble. And then with Bailey coming in, she came in as a transfer. And my daughter, has never been in any kind of trouble. And she's been telling me about Bailey. And, I told her probably don't let it get the best of you, don't fight. We've never been in trouble, mom and dad. And so when this happened, I told her, you can't put your hand, there's laws, you can't put your hands on anybody. You can't be fighting, you just got to walk away. And, I just told her, when that happened, just, next day, go talk to Bailey, tell her, I don't want to fight with you. Cause they have been friends. They've been friends. I've taken Bailey home from spare time and things like that when they've hung out. And she's, her mom has taken my daughter home. And I just, I don't know how it escalated to this. And, I asked Riley to just tell her, I'm sorry, Bailey, let's just stop talking about each other and move on. And then the next day came and the school told me, mom's pressing charges. So, yeah, we're here now. And so I told Riley, the consequences and, you shouldn't put your hands on anybody.
Okay. Well, I'm going to go ahead and order a 10-hour anger management class. I had up to 12 hours, but I've kind of cut it in the middle. There's usually, I never do 4, but there's 4, and then there's 8, 10, 12. I'm going to go with the one in the middle, 10. Okay. And that 10-hour class, Rayleigh, is going to be due June 21st. So you're going to have to get on it. And mom and dad are going to have to probably pay for that class because I'm assuming you don't have a job, right? Your job is school, right? So I can't court order this, but I can encourage you and your mom, especially. I wouldn't pay for that for her if she's not going to work it off through chores at home. And I mean quickly, because it's 10 hours and she only has 30 days. Rayleigh, that means you are going to have to snap to attention on this and really get with your mom after this call and figure out what it is you're going to do. The purpose is for you to gain a dismissal and not have this be a conviction on your record.
Yes,
And
ma'am.
right now, we want to get your attention quickly because things are not going well. Okay.
Yes, ma'am.
And I know I can hear in mom's voice, not just disappointment, but concern. Because what's going to happen if you start becoming a person with this type of activity in your record is people will start really, authority people like teachers and stuff, they're going to start looking differently at you. And you will not get the benefit of the doubt, if there's a benefit of the doubt to be had. And so it's really important for you to understand you're kind of at that place. And the class is designed to help you not come back in here, not need to be here again. Okay.
Yes, ma'am.
So I'm really going to encourage you to operate with mom and dad in really good faith to try to earn their trust back, because right now, that's shaky because they really trust you. And this is not easy for them either. Okay. No, it's not easy for you, but it's not easy for them. Right. And they want to be supportive of you and they want you to have a good future. And the way to do that is really to try to learn the most you can from this activity and get back to like 0.0 where things are neutral. Okay.
Yes, ma'am.
I don't know what the breakdown was with this person ultimately. Okay.
Yes, ma'am.
Bullying, I think.
Yeah, well, it does look like bullying, but it also looks like, you're pushing back. So from the authority standpoint, it looks like you're giving back as much as you're getting and that you're not being bullied. And so I don't know where it started. It's possible that it started that way, but it's escalating now. And escalating of this can get worse and worse. It's not going to necessarily get better because you fight back. Okay. And, or initiate a fight. And here, pushing someone from behind, it becomes not arguable when you do that. I mean, a person walking with their back to you didn't even know that it was going to happen. So that's not a fight. That's an assault. Okay. A fight is called an affray. Both people are doing it, and you can both be charged for that too. That's also an offense. Okay. So you'll work on some of this with your class. Okay. It's online. I want to encourage mom to encourage you to do it and maybe monitor that you're doing it. Okay. Because really the lesson is not to turn something into the court. The lesson is to get what you can out of a bad experience and a healthy class. Okay.
Yes, ma'am.
All right. So I do need y'all to come by sometime today to sign final documents, pay the $20 fee, and we'll give you a list of places where you can do the work, where you can do the class. Now, these are all, you know what, I'm going to go ahead and make it. There's only one 10-hour class. So I'm going to say, no, there's more than one. There's two. I'm going to go ahead and stick with 10. There's 2 places you could take it on this list. I think mental note, I'm going to just stay with 12, but I don't want to take it back. That wouldn't be fair. Okay. Let me hand this. What time should we look for you all to come by?
We can come by before noon. We can head this way after we get off.
Okay.
Your Honor, is there any way to get a note for Riley? She should be STAR testing right now.
Oh, absolutely. Yes, there's a way to get a note.
Thank you.
Okay. Okay, just come on by the court. We'll have notes here for you.
Thank you very much.
Thank you. Okay, bye.
Bye-bye.
Bye.
And then I also wanted to talk to Miss Blanding. Emily, can you unmute? Miss Blanding? Emily?
Can you
Blanding?
hear me?
Yes, I can hear you.
Yes, ma'am.
Good morning. I'm Judge Person. Let's see. We have 2 charges. They're both from April 4th. One is for a speeding charge, and the balance would be $259. The other is for no insurance, and the balance would be $281. And I did receive your information, including what's happened with your injury.
Yes.
So what I can do, there's a few ways to look at this. I definitely will declare that you are indigent and not able to make payment.
Yes, ma'am.
Of course, then the next thing is that I'm usually ordering community service, which probably is not going to work out on this, which is also okay. But what I normally do at this point is I go ahead and order the community service, but it's subject to doctor approval. And so what you would need to do, I'm going to give you 60 days to get me a doctor's note.
Yes, ma'am.
That says you can't do the community service. Does that make sense?
Mm-hmm. Yes, ma'am.
Okay. So it's 27 hours with a due date of July 19th. And then I'm going to make it subject to doctor approval, doctor note, saying you can or cannot do it. Okay. And it needs to be specific that you can't do it. Okay. And then I can waive it. Right. I will grant the deferred. I'm going to need your signature on the document for deferral.
Yes.
And you live in Temple, right?
Yes, ma'am.
Okay. Can you get to the court this morning or this afternoon?
This afternoon.
Okay. You know roughly what time?
I can be there by 12.
Okay. All right. I'll put down noon and we will see you then.
All right. Thank you so much.
Thank you, ma'am.
All right.
Bye-bye.
Bye-bye.
Okay. Mr. Mattson, I don't have the other attorney in yet. We're just sitting tight.
Sounds like a plan.
Okay. On this Michael Baines, here's the thing, and I can't get it. Please recognize I can't get it. So, I mean, I'm getting, this one doesn't want to do that, but do we have that written down? Well, those are notes by a clerk saying that the person doesn't want that. Does that mean that they talk to them and they're advocating to me because they're not allowed to do that? So, and that's a new employee. And I just want to confirm that somewhere in that file, he has written down that he understands he has the option to do community service, and that it's not that he can't do it, it's that he doesn't want it. Because that's why I wanted to talk to him. And he's not here.
Good morning, Your Honor.
Morning, Mr. Milam. How are you this morning?
I'm doing very well. How about yourself?
Fine.
Mr. Mattson?
Sorry.
So I'm just saying good morning, Mr. Mattson, as well.
Morning, Mr. Mellon. How are you?
Doing well, thanks.
So I received your motion, which took me by surprise considering the late date. But I went ahead and scheduled it for hearing.
You turn that up, I can't hear it.
I have it as loud as I can be.
Okay. My client are around sitting here on the other side of me right now.
Okay. Hang on just a moment. Did you print something for me? I misunderstood. Okay. So I guess it's your motion. Mr. Milam, you may proceed.
Hey, thank you, Judge. So as the court has already noticed, of course, this motion was filed outside of the 10-day time period normally called for under the rules of procedure for such motions. My argument, I think, is essentially an equitable one, including as to the timing. My client received notice of the judgment via mail and worked diligently to find counsel to help in the situation that he didn't obviously know anything about procedure, and was kind of the nature of a pro se. When the deadline actually passed, upon hiring me, I immediately filed this motion. The basis for the motion is that first, the judgment entered by the court incorrectly recites the nature and reason for why a judgment was entered in this case. Namely, if I ask the court to take notice of its own file, the order releasing defendant in PR bond shows an order to appear for March 22nd. And I think the testimony will show, if the court would like to hear from my client, will show that he did appear on that date. He signed some documents on that date that he didn't understand what they were, evidently. But the judgment does incorrectly recite that he failed to appear on March 24th, and that the failure to appear was the reason for the entry.
If I fix that, that doesn't jump the date ahead. If I cross it out, does it change the nature of the judgment?
I still think the judgment wasn't properly entered, and thus that it's not. There's an error on the face of the record that we should correct through a motion for new trial and reopen the case. Is my position.
That's not how you correct a judgment. You correct the judgment through a protect. You don't correct it by granting a new trial unless the judgment changes the nature of. For example, if I signed a speeding ticket conviction, I think, whoa, that's really different. But here, I just incorrectly recited something about how it proceeded, how it came forward. I was certainly perfectly aware that he had appeared because I had a written signature on 2 places, a plea of guilty.
No.
And I will say, I'm not entirely sure that you or Mr. Mattson have correctly identified the appeal timetable here, because this is not a court of record. And so I think you get 1 day, unless that's changed. It may have changed. I haven't looked. I think it might have changed in the last legislative session, the one before this one. I'll double check that. But we certainly give ample opportunity for people. And in this case, we did. I did not sign a judgment until the 28th. And I also mailed that out. And by, I think somewhere in here, I think I was given to believe that that was received by him very quickly after signature, my signature, before April. And then if assuming 10 days from the date that it went out, we would have needed something by, well, I'm showing it went out on the 30th. I signed it on the 28th. So even assuming that, which is a liberal construction, 10 days, if it's really 10 days, would be the 9th of April. I did not hear from anyone. Really, the motion that was filed let's see. Undated by your office. When did we receive it? The motion by the law office.
I believe that would have been April 14th that I sent it. I'm trying to find the email that I can see where I have a receipt from it, but certainly more than 10 days after the judgment was signed or mailed.
I don't think the court sits in equity on a jurisdictional issue. I don't. Can you convince me otherwise? Because I don't. I understand that you're claiming it's an equitable issue, but I don't think that I'm able to sit in equity over jurisdiction matters. It's kind of like if somebody filed a Class B offense and I made a mistake and it sentenced a person to a Class B offense in a Class C court. Well, I never had jurisdiction to begin with. So that's different. That's not equity. Here, a judgment was entered, it was made final, notice was given, and I don't think after a fashion, the court can sit in equity during sentencing, but I don't see the court sitting in equity over a jurisdictional matter. Jurisdictional matters are not decided by this court other than a threshold. Do I have jurisdiction to sign a judgment? Here, I think I did. So I understand that you're saying it's equity, and I understand why you want to say that, because you feel like your client didn't understand what he was signing. But you know, the fact is there's 2 pleas that got entered, and I waited to execute those pleas several days in both cases, neither of which is required. Normally, you enter a plea, I find you guilty, we move on down the road. And here I did wait in case. I don't think that I have the ability to act on your motion.
Okay, so when I filed the motion, I was not in position.
Let's say I fully agreed that, and I'm not saying that I do agree. I think actually we took more care than we normally do because of the nature of it. That said, and I don't know what your client has been made to understand from you, but the fact is, I don't think that I have jurisdiction to even rule on your motion, except to say, duly noted, I understand what your motion says. So I don't even know that I can even deny it, to be honest. I have to think about that a little more. But I think what I have jurisdiction over did he pay his fines and costs? And I think we're all in agreement here that he served that time. He served ample amount of time for me to give him full credit. I don't think that's in dispute, but I don't think I have jurisdiction to vacate a judgment at this point.
And Judge, to make sure I'm clear, obviously I haven't, if there's a corrected judgment, is the one that recites the March 24th date and the failure to appear as the basis for the deemed entry of plea, is that still the
I think that that's deemed the reason for entry. I think that I was executing on his plea, and I don't think that he was here in court when I did it. That's certainly what I thought was happening. I think if I modified that and initialed it and said, okay, correction, not pro tunc, I'll ask the clerk to change what that reads. I could change what that reads.
I guess
I cannot change the date on it.
I appreciate that you were. I think you've correctly identified my issue here. My position, if I can make the cognizable legal argument I'd like to make, is that I believe this judgment, as it contains an error and it's not one that is subject to correction via clerical error, it actually recites a completely different.
No, it's a clerical error
For the entry of his plea. I understand. And I know this can reasonably be disagreed with. This is just my argument is that it's a substantive error, and then plenary power has not exhausted because there's the substantive error in the judgment. I understand if the court disagrees with that and wishes to deny my motion, but that's my claim. At the time I filed this, I was unaware of the plea documents. All I had was the PR bond and the non-matching judgment. When I filed this, Mr. Mattson in his response motion brought to my attention the plea documents signed by my client on March 22nd. And we have no argument that those certainly were signed by him. I think it's factually correct that he did not, after speaking with him, fundamentally understand the significance of the documents that he is signing. I understand that also may not be the court's problem to solve for him. But that would be my argument, Judge, that there's error on the face of the record because of the error that is recited in the judgment there, and that if plenary power hasn't exhausted, then the motion for new trial would still be proper. Actually, the motion for new trial might be early if there's no judgment then, but then the case would still be open, and my client would wish to at that point to withdraw his plea if not of no contest.
Mr. Mattson, what do you say?
Your Honor, I do disagree with the notion that the judgment has a substantive error in it. It is essentially just an extra line of text that, if removed, does not change what the judgment itself is rendering to the defendant in this case. Mr. Malum does concede that his client signed the plea, and I noted in my motion that he also signed the stipulation to family relationship. So I don't think that the court is within according to the rules of appellate procedure and criminal procedure, the court does not have the ability to vacate the judgment and allow for a new trial in this case.
So yeah, this really comes down to the fact that Class C courts allow pleas at the window. Heck, you can send a dollar bill in and that's considered a plea, even if you didn't write anything down. And then if you reverse that and tell everyone, because you drove through Temple, you have to drive back over here to give us your $1. I mean, people would go crazy with that one,
Sure.
It's a sort of darned if you do, darned if you don't proposition for Class C courts. I've studied it for 20 years now. I've been on every board of directors that can be on. I've been on every advisory board. And what I'll tell you is, if your client wasn't in front of me when I entered that plea, I really wasn't thinking about that he appeared at the window. Now, the flip part to that is, you're saying it's substantive. What if it said he did appear? He appeared and entered a plea.
Then I don't think that there wouldn't be an error if it correctly recited that he appeared, entered a plea of no
Right,
contest, and you were finding him guilty based on that, but it doesn't say that.
Yeah, well, I know, but that's not a fact. Is that an element of the offense now? We're saying that it's an element of the offense?
No, but the judgment does have to correctly recite the way in which he pled, and that the finding was based on the plea, not based on his failure to
Do you
appear.
have case law that says that if there's a clerical error of that level, that it is a jurisdictionally binding error?
I do not.
I don't think there is any, because I simply don't think that that's the case. To the degree that I have the authority to deny the motion, I'm going to deny it at this time. I am going to I'm going to say this. I'm going to do a little bit more research online before I deny it. I don't anticipate finding anything that I have not found, but I'm going to give it one more go and see if there's anything that gives me jurisdiction. But I simply don't believe I have jurisdiction to make such an order. I just don't. The pleadings have not convinced me that I have jurisdiction. I'm not, in my deep understanding of appellate law, which was my practice for many, many years, I don't. I've seen a number of, I've seen note pro tuncs that were, I thought, frankly, were substantive, but and jurisdictional. But the appellate courts, in fact, said they were not. So I don't think that I have the authority to do that. But, you know, the new law is we send out that notice about regarding the firearms issue. And I definitely make sure that we send that out. That's why I remember this case. I remember, you know, making sure that we had what we needed to proceed. So I don't know that we have, I don't think I have the authority to do more than just leave it where it is. I don't know that I even have authority to sign a denial. I mean, I'm actually just as interested in that issue, whether I even have authority to deny the motion. I'm not positive that I even do. My first instinct was to send it back and say, I'm sorry, I can't accept the pleading. But I decided, because it was a jurisdictional issue, to go ahead and have a hearing and allow everybody to flesh it out as much as they could. And I'll look a little bit further, but I don't anticipate, don't get excited about that, but I will make sure that I am confident. And to the degree that I agree or disagree, I would, if I deny the motion, it's not because I think I have added jurisdiction. It's to signal to you what my decision has been.
Okay, I understand that, Your Honor. I also simultaneously filed a notice of appeal, and with a similar and understandably perhaps specious argument, given my late timing to do so. May I assume your position about the ability to appeal is similar, or do you feel differently? Your understanding, I think, of this issue being far deeper than mine.
Well, so that's an interesting issue too. You know, I do think that it's possible that I might have to send that over and see what the appellate court would do with it. But I'm not at all confident that I'm required to do that at this point, but I will check on that as well.
Okay, I appreciate it, Your Honor. I don't have anything further this morning.
Okay, Mr. Mattson, do you have anything further?
Not at this time, Your Honor.
Thank you.